We get started. All right, well, we are going to get started. Welcome and thank you everyone for joining us today. You are our second of 25 events for Spring Alumni Week, so hopefully we'll see you throughout the next few days. Just a few housekeeping notes. We are recording the CLE. And then we'll have some time at the end for questions. So please hold your questions for then. We also, if you would like to go with Professor Greenwood to the Rare Books Library after the CLE, they'll have some of the materials that they're discussing during the CLE on display. So we're just going to have everyone gather out where you signed your CLE forms if you want to go there afterwards. But let me introduce our speakers for today. Professor Ryan Greenwood specializes in rare books and historical legal research. His areas of scholarship include the history of rights and international law. He is the curator of rare books and special collections in the Law Library's Reisenfeld Rare Books Center, where he stewards the library's rare books collection and the law school's archives. Professor Greenwood earned a BA from the University of Chicago, an MA and PhD from the University of Toronto, and an MLIS from Rutgers University. Professor Sam Merchant is an associate professor of law. His research centers on sentencing theory and the intersection of criminal law and constitutional law. His scholarship analyzes modern criminal and constitutional practices through an empirical and historical lens. He included common law, sentencing, and habeas corpus. Professor Merchant is a member of the United States Sentencing Commission's Research and Data Practices Advisory Group and is a research fellow at the Georgetown Law Center for Constitution. From 2022 to 2023, he served as a fellow at the Supreme Court of the United States, working at both the Supreme Court and the United States Sentencing Commission. Professor Merchant has authored several law review articles and the book Revolution of Redline, The Iterative Journey of the U.S. Constitution, which traces the documents and ideas that inspired the founding documents and examines the drafting history of America's founding documents. So thank you so much to our professors for your time today, and let's dig into our topic.
Well, thanks, folks. Thanks for coming out today. And I'm Ryan. I guess I'll go first and try to provide an introduction for Sam's part. This is the sort of deep historical part of it, based in our sort of rare books collection. And hopefully kind of fun and interesting as some of the like deep genetic history of where we get to today with constitutions, or where we got to in 1787, 1789. And it starts like, a long time ago. So I'll go quickly through it and then turn it over to Sam. This is just a plug for the Rare Books Collection. Again, we've got one of the best collections of rare books in the country, going back to 1477, a great collection of early English law. So a lot of the stuff that we're going to talk about today, and we met before to like look at it and pick out some of the stuff, we have. So we can show you afterwards if you do have time after lunch and you have a minute to come back and kind of see some of the documents. We've got old copies of Magna Carta and the Petition of Right that we'll look at, and the English Bill of Rights, 1689, and all sorts of really cool stuff. So a big part of my part is the rare books and the items that we have in our collection. This is one of them that we can look at. This is sort of the, just starting very quickly with Magna Carta for anyone who has interest. Well, in fact, you have to go before Magna Carta to even talk about Magna Carta. Post-conquest in 1066, this is really the first set of written laws. So William the Conqueror didn't produce anything, and his son Henry I ordered or offered this kind of charter of liberties. And it was for like in return for support. So already it has a kind of contractual character to it. And it's a promise to return to good old laws and customs. So anyone who thinks that 1066 and the Norman Conquest was like an easy time for Anglo-Saxon society and all this, not quite. And what Henry had to do was even promised to return to the law of King Edward, It was the last like legitimate Anglo-Saxon king before William came to England. So part of it is sort of restoring law and justice in some good old time. There were no written laws of Edward the Confessor, so this is sort of an appeal to a golden period. But he's writing it down and he's offering it in return for essentially support in 1100. So this is kind of like the beginning of a constitutional tradition in England. The second one, of course, is Magna Carta and the road to Runnymede. This is kind of a story in part about bad kings. And King John was a pretty egregiously bad one. These are some of the key grievances. And as you'll see, in the documents that are submitted to royal authority or to Parliament, you get lists of grievances, which is really kind of an important form when folks are asking for recognition of rights. So John lost a war. He imposed arbitrary fines and taxes. Probably he wasn't doing anything very much more than his brother Richard the Lionheart did, and his father King Henry II. But it was at least a matter of degree, and raised a lot of taxes from the people in a way that made them pretty unhappy. And arbitrary fines and taxes, he went after enemies and hounded some people to death, killed his nephew, and did all sorts of unpleasant medieval things. And also sought control of the English church. He was excommunicated by the Pope. And so he had trouble throughout his reign. And then it came to a head. He tried to recapture Normandy in 1214, and it didn't work. There was a group of what became rebel barons, generally from the north or led by some folks from the north. And the first document on the road to Magna Carta, and the first sort of iteration of Magna Carta, and a lot of this has to do with an iterative sort of process and an iterative journey of constitutional documents and constitutional rights. But the first one is the Unknown Charter. It's only known in one manuscript copy in Paris, and it has at the beginning of it Henry I's Charter of Liberties. So they write out Henry I's Charter of Liberties, and then there's 12 clauses. And at the beginning of the 12 clauses, it says that King John has agreed to these. Whether it's true or not, we don't know. It seems that he probably didn't. And there was a series of negotiations and maneuvers in the spring of 1215. And finally, John was cornered in London. He realized he didn't have support, so he went to Runnymede and he agreed to a peace treaty, which was really a capitulation, which came to be called Magna Carta. The Articles of the Barons are just an early draft of Magna Carta, or actually I should say it's kind of a final draft. And John agrees to it. It has 48 clauses. It's pretty robust. But 5 days later, the sort of final engrossed Magna Carta is produced on June 15th, and there's 63 clauses. So it's like the most robust, and it limits John's power to the greatest extent. He effectively loses sovereignty to a committee of 25 barons. But what happens is he renounces the charter immediately afterwards, after he can sort of get out of Runnymede and escape. The Pope supports him, and then he dies. So in 1216, his son Henry III comes to power and is forced in a way that's a little bit similar to Henry I in 1100. He's forced to reissue the charter in return for support. So he reissues it, and it's really under his regent William Marshall, because he's a minor. But he strips out a lot of the most robust clauses that protect rights and liberties, and then he strips out all of the enforcement clauses, which we'll look at in a second. Magna Carta 1217 is a similar deal. It goes up to 43 clauses, but all of the the most I guess the meatiest of the clauses, or the meatiest of the document, is kind of taken out of it. But we'll look at some of the things that remained. And then 1225 is the final version of 37. So it's the shortest version of it. And it becomes statute in 1297. So Magna Carta, for all those folks who say Magna Carta is a myth, it's not a myth. It was statute. And the other thing people often say about Magna Carta is that really only had application to feudal nobility and things like that, which is also untrue, which we'll look at in a second. But just as a final comment on Magna Carta 1225, Henry faced a series of civil wars throughout his reign, and he was forced to reissue Magna Carta in the 1225 form again and again and again over a 44-year reign. And it was always in return for support and tax money. So it was, the sort of contractual nature of it and the constitutional nature of it, I think is, I think it's pretty clear. But that's kind of a short story of kind of the iterative journey of Magna Carta, which, like the Constitution and a lot of our documents have, has a sort of backstory to it. Just to look at a few of the clauses. So it's clearly a charter of liberties, and he's offering it as a charter of liberties in the original version. And the clause 14 is to obtain general consent of the realm for the assessment of an aid. So this is like no taxation without representation. There is no sort of formal rule or regulation for calling a parliament. In the period, it's just with advice and consult of barons. So there's phrases like that you find in documents from the same time, but that's kind of the origin of the English Parliament. And Henry III's successor, Edward I, starts to call Parliament regularly, and it becomes an English institution under Edward I. But this is just sort of an expression of a parliamentary idea, and it's for taxes. And on the other side, it also became kind of common. It was expected that on the other side, the barons or whoever is being represented there is going to, sort of air their grievances or effectively petition the king. 28 is a bit of an early forerunner of the takings clause. No, you can't be put on trial upon an unsupported statement, usually of a sheriff or bailiff or something like that, without producing credible witnesses. And then 39 is, of course, the most famous part of Magna Carta, and it is like the origin of the due process clause. Just so these things were all stripped out. 52 and 55 in the original Magna Carta are the sort of security clauses or enforcement clauses. There are a few of the security or enforcement clauses. And so cases of dispute, the matter shall be resolved by judgment of the 25 barons. And of course that gets taken out because that's, an imposition on royal authority. And the clause on taxation, number 14, was taken out. But somewhat interestingly, this phrase, liberties or free customs, was inserted in 1225. And it's really kind of interesting because you have in this document, and you could argue in 1225, that what you're really already talking about fundamentally is life, liberty, and property. And that, the whole sort of subsequent history is a kind of analysis and meditation on that provision, and on life, liberty, and property. And you have the US Constitution, Fifth Amendment, a few years later. That's that. Just as there's a second moment of constitutional crisis in 16. I mean, it really goes to the beginning of King James I's reign. He's trying to raise money by various means. He's a rather lavish fellow, and if he can't raise money from Parliament, which by this time is the accepted way of raising tax money, and it's statute that Parliament raises taxes and has to consent to taxes. So that already is there. But if he can't get Parliament to agree to what he wants, he dissolves Parliament, and then he uses forced loans and indirect tax. This fellow, Edward Coke, had a problem with that.
Cook was Solicitor General, Attorney General, and then became Chief Justice of the Common Pleas and then King's Bench. Before his downfall was engineered by Francis Bacon. Interesting. Very, very, deep sworn enemy of Francis Bacon. In any case, so Cook is opposed to King James in a series of cases when he's on the bench before he's kicked off of the bench, and he doesn't have job protection at the time, but he basically is making various gestures that the judiciary is at least somewhat independent. Bonham's case is probably the famous one, but there's a series of cases. And then he reports on them himself in his law reports, which is kind of fun. He becomes the most famous law reporter in the 17th century. In the 18th century, everyone studies them. All the American colonists study Cook, and he's like the fountain of law and justice for a lot of folks who are coming up through the Inns of Court and who are lawyers. And many of those folks are also sitting in the House of Commons. Okay, so by this point, a lot of folks who are in the House of Commons are lawyers. The Petition of Right, the architect of the Petition of Right is Edward Cook. And so he's kicked off the bench. He goes into the House of Commons, and there's a case that sort of precipitates it, Darnell's case. There's a forced loan that now Charles I has levied, and these folks don't want to pay it. They get thrown in jail. They petition for a writ of habeas corpus. It's denied, and the reply on the writ is just that they've been imprisoned by the King's royal command. So there's no reason, and they can't get the cause of the cause for the imprisonment, and the judge just sort of backs off. So the House of Commons kind of goes nuts, and they present a series of resolutions to Charles I, and then eventually it reaches this form of the Petition of Right to confirm the rights of English subjects. And so cease taxation without parliamentary consent, which is already statute, and then Magna Carta is cited. And Cook really loved to cite Magna Carta. So this is like, in this period, it's like the political rebirth of Magna Carta as a document that expresses English rights and liberties. And then there's a few things always with these like new constitutional moments. You have some, new grievances or new rights that are expressed that have much more to do with that particular context. So this was something that Charles was involved in, martial law, and there was violation of due process, quartering of soldiers in private houses. Of course, that gets into our Bill of Rights as well. So that's that. This is just another, just a quick tour before I sign off here. During the English Civil War, I guess this kind of constitutional crisis that begins with James I continues through the English Civil War about 1650. Charles I is eventually executed for treason against the state. It's, of course, the product of the English Civil War. The Parliament raises an army and goes to war against Charles I. At the end of the war, there's a group of people, the levelers, and there's a series of documents, an agreement of the people, and a few of them agreements of the people, where they're sort of asking for some new rights or want them to be articulated, and they're thinking of possibly a government beyond a royal government or a sovereign that's limited in a much stronger way. This is a kind of equal application of the laws clause. There's a freedom of religion they start to talk about. And they want to put down in kind of more detail how Parliament will be called and how frequently it will be held. Universal male suffrage, some of them talk about. So there's sort of more radical movements that come out of the English Civil War. Cromwell came to power, and he was ruled the protectorate, and then there's a restoration afterwards. So some of these things don't really come to pass, but people don't really forget about them either, obviously. So there's other sources of constitutional rights in English sort of legal and constitutional history. And just as a last comment before I'll turn it over to Sam, on English Bill of Rights, probably the third great English constitutional crisis or moment. There's a Catholic King James II, and he produces a male heir who's Catholic, and the country, particularly being led by Parliament, who's Anglican and against the Catholics, chases him out of the country, and they invite William of Orange to come and become King of England, and they have to figure out exactly how this happened. As a legal matter, it's pretty dicey, but they get William to agree to a list of rights, some of which again are sort of backward looking to an older tradition. Taxation must be with the consent of Parliament, super important for them. Parliamentary elections must be free and Parliament should be held frequently. Still also a little bit backward looking. There were some legislation passed during the Civil War, English Civil War, that did the same thing. There was one called the Triennial Act. Freedom of speech in Parliament, also sort of looking back to a little bit earlier context and during the Civil War where people were afraid to speak freely in Parliament. Right to petition the king, of course, very old right, one of the original rights. But now you have some new things, no excessive fines and cruel and unusual punishments, right? So Eighth Amendment, and then fines and forfeitures before conviction, and right to bear arms. But it's really against Catholics. It's only for Protestants. So that's kind of that's rights sometimes have interesting origins. That's the point. And then the way it comes over, just very briefly, the way it comes over to the colonists, the original charters for all the colonies have this language that as if they had been, born, they have all the rights and privileges of English subjects and, liberties, franchises, and immunities. And then when matters really come to a head for the colonists in the 1760s and early 1770s, they're saying, well, which rights do we have? We should have the full rights of English subjects, and we don't have that. So it's not just taxation. Taxation of that representation is a big deal, but it's like, how are any of our interests represented? And there were various discussions about that, but that's kind of that's a quick tour that I can offer for the first part of it. And now maybe I can turn it over to Sam and yeah.
So for my portion, I'll pick up on primarily on the other side of the pond in colonial America. But I will start, and with this presentation, I sort of deliberated on how best to present this. Most of this stuff is in my book already, and so the thought was, why don't I just go through the book instead of trying to do screenshots and stuff in a PowerPoint presentation. So this is just an ebook version of my book that came out earlier this year, which collects a lot of these documents that Ryan talked about and that I'm going to talk about that sort of show the journey of the U.S. Constitution and our founding documents through English history and through the founding. And then I take you sort of through the drafting journey as well, the founding documents, and we'll talk about that. But I start with Magna Carta, and Ryan went a little bit before Magna Carta. I start with Magna Carta. I include sort of the full text. There's some introductory commentary from me showing how it relates to the U.S. Constitution. And then you have the full text of these documents in the book. And I'll start with today with the English Bill of Rights. And primarily, we saw some of the provisions of the English Bill of Rights during Ryan's presentation. I primarily want to focus on the structure of the English Bill of Rights. And the structure here, just to put a pin in this for later, we start with a preamble and then a statement of grievances, suspending Parliament, issuing commissions under the Great Seal, levying money without Parliament, keeping and raising a standing army, all these grievances, excessive fines, cruel and unusual punishment, and then a statement of rights saying we have these rights and these grievances are a violation of these rights. And some of these, I'm sure, will stand out to you because they get constitutionalized in the American system. So this has been a discussion that has been happening for well over 100 years by the time it gets to the American Constitution. We've got a preamble, grievances, a statement of right, and then what are we going to do about it? There's succession, basically, here for a new ruler to take over. We get to the 1765 Declaration of Rights and Grievances. This is about 100 years later and across the pond in the United States, where the colonists are complaining about the Stamp Act and saying you have these you have these taxes without representation here in the form of the Stamp Act. We're not being represented in the same way that British subjects are represented in England, and that's a violation of our rights. And so what will we do about it? Well, first of all, we'll have this declaration of our rights and our grievances. And again, starts out with a preamble, a bunch of grievances that kind of mix in a statement of rights. So His Majesty's liege subjects, these colonies, are entitled to all inherent rights and privileges of his natural born subjects within the kingdom of Great Britain. This sort of gets converted into privileges and immunities in the American system. But a lot of these things had predated the founding documents by decades or centuries. So combination here, right to the jury trial is inherent by all British subjects, and we're being denied that. We're being taxed without representation, et cetera, et cetera. So the colonists are saying this a decade before declaring independence. The Crown's response, well, Parliament's response to that is the Declaratory Act. And in the Declaratory Act, we see, well, eventually the Stamp Act gets repealed only to be replaced by other oppressive acts, including the Declaratory Act. In the Declaratory Act, I'll flag this for later as well, Parliament says that that the said colonies and plantations in America have been, are, and of right ought to be subordinate unto and dependent upon the imperial crown and Parliament of Great Britain. That language probably sounds familiar because in what I call the early case of colonial trolling, the colonists use that language against the British in the Declaration of Independence, which we'll see. Colonies are of right and ought to be independent. And so we'll see that in the Declaration, kind of a callback to the Declaratory Act. Ryan mentioned this, but the Declaratory Act infuriated colonists because it purported to bind the colonies in, quote, all cases whatsoever. And so just supreme power over the colonies, and the colonies don't have representation in Parliament to do anything about it. A few years later, we get the Declaration of Resolves. And this is the colonists again declaring certain rights, declaring certain grievances, the First Continental Congress getting together and submitting this to England, saying, we have these statutes that were passed without our representation, standing armies in a time of peace, all these kind of grievances that we'll see later in the Declaration of Independence. We have these statutes that we think that these are invalid, unjust, unconstitutional, et cetera, et cetera. The colonists are complaining about that. It's resolved that we have these rights. We're entitled to life, liberty, and property. Our ancestors settled these colonies. We didn't give up these rights at any point. And so sort of a declaration of rights that predates the Declaration of Independence. And part of the theme of the book in this discussion is where the drafters are sort of borrowing from prior documents and putting them into the founding documents. So here again, we get a Declaration of Rights, we get grievances, and then we get toward the end of the 1774 Declaration and Resolve. What are we going to do about it? So similar structure that we saw in the English Bill of Rights. What the colonists say they're going to do about it is in this last paragraph. We're going to enter into a non-importation, non-consumption, non-exportation agreement. We're going to boycott British goods, and we're not going to trade with Great Britain. And we're going to prepare an address to the people of Great Britain and a memorial to the inhabitants of the colonies and prepare an address to His Majesty. So that's what we're going to do about it, basically. To comply with this and sort of in advance of this provision, the colonists next passed, about a week later, the Articles of Association. And in the Articles of Association, this is the colonies getting together. And finally, you see this like sort of recreation of Franklin's famous cartoon, Unite or Die, from sort of derivative of a prior cartoon, Join or Die, galvanizing support for the French and Indian War. But the colonists get together and realize there's come strength in unity. They have to fight together. They can't be separate here. If you have one colony that doesn't cooperate, the whole thing could fall apart. So we have to be united. The first way that we're going to do that is through the Articles of Association. Lincoln says the Articles of Association are actually the foundation of the country, the origin of the United States. Not the Declaration of Independence, not the Constitution, but the Articles of Association, the first time they agreed to associate together and become one. And from that point, Lincoln says, we formed a more perfect union, but it all starts with the Articles of Association. So in the Articles of Association, we get, first of all, a pledge of loyalty. We promise we're still loyal to you, to the crown, but situation is such that we need to associate with each other and demonstrate unity, and so we're going to boycott British goods. And there's also, interestingly, a prohibition on the importation of slaves and the slave trade. This is not certainly some of the drafters were abolitionists and disagreed with slavery, but this is primarily because slavery had become so lucrative for the British. So this is a way to sort of undercut the British economy by banning the slave trade in the colonies. Boycotting East India tea. So a lot of different provisions here. I always find this interesting. Wool was very scarce and very important, and so there's a commitment to sort of preserve sheep and to not waste wool in the colonies. And then there's also a frugality and extravagance commitment. So we promise we're not going to be too extravagant. We're going to conserve our resources here and not buy things we don't need and use things we don't need. We're not going to price gouge. And then we'll have local oversight committees who will make sure that each colony in each town is complying with the provisions of the Articles of Association. And if any state, or I guess any colony at this point, isn't cooperating, then we will exclude them from trade and from commerce within the other colonies. And we'll also shame them in gazettes and newsletters and things like that. That's what the articles say as a deterrent here. Also accompanying the 1774 Declaration and Resolves, it said we're going to draft a petition to King George. This is that petition. And so most of these documents at this time are drafted by John Dickinson, who's just a fantastic sort of writer. And so a petition to King George, we're still loyal to you, but here are these things that we are going to blame on Parliament. We're not going to blame you yet, but we're going to blame Parliament. Standing armies are among us. You've created all these offices, or Parliament's created all these offices that are foreign to us, and they're being paid and sort of trying to run our towns. Judges have been made entirely dependent on Parliament for their salaries, et cetera, et cetera. So a lot of these grievances that end up getting lodged at the Crown in the Declaration of Independence. One other thing we get here, John Dickinson's sort of last-ditch effort to reconcile with England. He says we need to really let's try one more attempt to reconcile. So they send the Olive Branch petition. The Crown and Parliament ignore the petition to King George, and they ignore the Olive Branch petition. Olive Branch petition, and ultimately that leads to the war. The next sort of document we get is the Declaration and Causes of taking up arms. We've tried to petition you. We've tried all these different things. By this point, there had been several skirmishes between the colonists and the British. And so we have no choice, according to the colonists, but to take up arms against Great Britain. Legislature of Great Britain, however, passed an inordinate passion of power, not only unjustifiable, but which they know to be peculiarly reprobated by the very constitution of that kingdom. So they're passing all these unconstitutional laws. Interestingly, through a lot of these documents, you hear complaints about Great Britain enslaving the colonists. So some scholars have said these are clear indications that the drafters knew how unjust slavery was, because they're using that and saying that it's unjust to enslave the colonies. So by extension, obviously, it would be unjust to enslave human beings. There's kind of a contradiction there in some of these documents. But nonetheless, we have the Declaration of Causes of taking up arms, setting forth all the reasons that we now have to take up arms against England. One thing I think is interesting about this document, this is also drafted by John Dickinson, and it starts out, if it was possible for men who exercise their reason to believe that the divine author of our existence intended a part of the human race to hold an absolute property in and an unbounded power over others, marked by his infinite goodness and wisdom, as objects of legal domination, never rightfully resistible, however severe and oppressive the inhabitants of these colonies might at least require from Parliament of Great Britain some evidence that this dreadful authority over them has been granted to that body, but they haven't been granted to that body. So, I mean, a very good writer, a very powerful writer. And I point that out, John Dickinson, because as the drafter of most of these documents that we're going over, He would have drafted the Declaration of Independence, but he opposed independence. And so the job goes to Thomas Jefferson. So if you kind of want to see what the Declaration would have looked like had Dickinson not opposed independence, it probably would have looked a lot like the Declaration on causes and necessity of taking up arms. He's also much more religious than Jefferson, and so there's a lot more religious allusions in this declaration. And it also has a fascinating sort of history of the early American colonies and settlement in the colonies, if you're interested in that. The king's response to that, a proclamation declaring that the colonies are obviously in rebellion and seditious, which is under British law true at the time. And so the king says, you're being seditious, and for that, then I declare that all subjects in England and in the colonies have to fight against these seditious members and report on your neighbors if they are rebellious and traitorous. And so this is a real threat. And we see some of this in the Declaration of Independence, which we'll talk about. We've talked about some of these declarations already, and then we get to the big one, July 4th, 1776, the Declaration of Independence. And here we have, again, Jefferson borrowing the structure of prior documents that came before him. We get a preamble, we have a statement of rights, and then we have a huge statement of grievances, largely plucked from prior documents, some of these going back to the English Bill of Rights. A lot of these going back to the English Bill of Rights. I don't mean this to sort of demean Jefferson or anything. It just wasn't a concern at the time that you would sort of plagiarize prior documents that came before you. And Jefferson even says it wasn't our job to sort of create these new lofty principles. We were supposed to capture the sentiments of the moment. That was it. So it's not sort of a strike against him for sort of picking and choosing and piecing together what he thinks are the sentiments of the moment. But we see a lot of these same grievances that we've seen in prior documents. He's refused to assent to our laws. We're trying to pass these laws, but they won't let us. They're dissolving our houses of representation. He's obstructed the administration of justice. He's made judges dependent on his will alone. Now that converts what we just looked at, Parliament's will alone. Now these are charged directly at the king. In this section, multiple new offices have been erected, standing armies in a time of peace, et cetera, et cetera. So a lot of the grievances that you are familiar with already. And then we get a conclusion. What are we going to do about it? We're going to declare independence and create our own country. And we get this line that we saw from the Declaratory Act that I called colonial trolling, that these states are of right and ought to be free and independent states, fully absolved from allegiance to the British Crown. We get our first attempt at a constitution in the colonies with the Articles of Confederation. By all accounts, a complete failure, but they were good enough to sort of get us through the Revolutionary War. Articles of Confederation, some notable things about the Articles. There is no judiciary, there's no executive branch, it's just Congress, and Congress handles everything. The president at the time literally just presided over Congress. This is why some think, of course, that Congress is first among equals in our current systems. For this, in the first Constitution, there weren't even other branches. So tries to structure government. In this document, though, there are no protections for rights. Rights were protected. You look to your states to protect rights at this level, not the federal government. Probably most fatally here, there wasn't a reliable funding mechanism for the federal government. So you depended on voluntary payments from the states. And if the states didn't pay, the federal government sort of collapses. That gets fixed in the US Constitution by having the ability to individually tax citizens instead of relying on states to advance payments. Then we get to the US Constitution, and of course, we've got our separate articles. And now we have three branches of government trying to structure our system of government, and certain protections of rights that are in the document itself, and then some that get added at the end in the Bill of Rights. I also include in this document that sort of covers what I call the historical journey of the founding documents. So a lot of the documents that led to the founding documents. But I also include, I think is interesting, and what I wished all of this existed when I was in practice, so that I could get sort of a crash course and a one-stop shop for all this history,
But I also include what I call the drafting history of the founding documents. And the easiest way and the most concise way I thought of to present that, especially for lawyers, is in redline. And so I present the founding documents, starting with the declaration, in redline. So you can see the changes that the drafters made and explore why they made those changes to a key draft. If they're making changes, presumably they have a reason for the change. And so we can sort of learn about the document, the deliberative process that went into it, and the reasons for some of these changes. And so here's the redline version of the Declaration of Independence, where you can see Jefferson's last draft versus what the Congress changed in his last draft. He was pretty furious about these changes. He said Congress had mutilated the document, and he sent copies to his friends of his version saying, here's the better version of the Declaration that Congress mutilated. But there are some changes here. So one I point out just on the first page here, Jefferson used this language that we're all familiar with. Well, the final language, separate and equal station, right? Jefferson's language was separate and independent station. But certain states thought that Jefferson was trying to sneak in equality for slaves through this document. And so they went through and sort of changed a lot of the provisions that they thought were a little too friendly to slaves. And it's interesting, as I note here, Justice Taney in Dred Scott quotes the final language, separate and equal station. And you can think if it had said separate, or said equal and independent station, Justice Taney probably couldn't have cited that language in Dred Scott to demonstrate separate but equal. So there's a lot of changes like that, that looking at this in redline, some of the changes jump off the page. Franklin and Adams have a lot of changes here to some tweaks to Jefferson's language, and then Congress has some major tweaks to the language. All of these, again, presumably have a reason for the change. Some grievances get added, some grievances get deleted that Jefferson wanted to include. An interesting one that some of you have probably heard of, but Jefferson has this entire screed in his draft of the Declaration against slavery. And he calls out the king, which is a little bit of a stretch, but he calls out the king for American slavery, saying he's waged cruel war against human nature itself for violating its most sacred right of life and liberty in the persons of a distant people who have never offended him, captivating and carrying them into slavery in another hemisphere, or to incur miserable death on the transportation there, right? He's supposed to be this Christian king, but he's engaging in this horrific practice. So Jefferson wants this in the Declaration of Independence. Southern states say, absolutely not. Like, we're not having that in the Declaration of Independence. And so they insist that that gets cut, and it ultimately gets cut. So there's a lot that we can learn through looking at the drafting history of these documents. Do the same thing with the Articles of Confederation, where you can sort of see the deliberative process around the Articles of Confederation. One other thing here, at least for the ebook readers, you can click on any image in the text and it takes you directly to that primary source. So here are the Journals of the Continental Congress. And first of all, verify that I say correctly what I say in the book, but also be a starting place for your own research on these issues. So all of these are linked, and then there are several other hyperlinks for factual claims that I make in the book to sort of be a starting place for research. The Constitution has a lot of really interesting redline changes in it that we can talk about. I'll start with one. First of all, the last delegates who had their hands on the document is the Committee of Style, led by Gouverneur Morris. And some scholars have now sort of made the argument that Gouverneur Morris surreptitiously made changes to the draft, that this was at the end of the convention. Everyone's hot, tired, smelly. They want to go home. And so he sneaks in these changes, and most of them they don't catch, right? And so some of these were debates that he advocated for and lost, and then they get snuck into the Constitution. A couple of them he gets caught. And they say, now, wait a minute, that's not what we agreed on, right? Oh, it must have been a typo, right? And then they change it back. So there's some interesting stuff in here that the red lines can show based on that. One of the main ones The vesting clause of Article 1, all legislative powers herein granted shall be vested in a Congress of the United States. Morris added herein granted as just a subtle way to try to limit the powers of Congress and to spread the powers out across the other branches. The vesting clauses of other articles don't have this in it. So one argument there that he is sneaking in some changes for a constitution that he wants to create. Another is on here in section 3 here, where we get the Article 4, Section 3, we get the addition of new states. He adds this language, which effectively makes it a little bit harder to add new states. And he was concerned that with westward expansion, that the power of the original states, the 13 original states, would be diminished with the addition of more and more states, which is true. But he was concerned about that. And so he wanted really those new areas of the country to be territories and not states. And so he made it a little bit harder to add new states. Ultimately, it's relatively easy to add new states, but he tried to make it a little bit harder than the original draft did. You can look at the same in the amendments here, and in particular, the Second Amendment is always interesting to look at the changes to the Second Amendment. So the original draft said, well-regulated militia composed of a body of the people being necessary to the security of a free state, right of the people to keep and bear arms shall not be infringed, but no one religiously scrupulous of bearing arms shall be compelled to render military service in person. So if you look at this draft and prior drafts and drafts that existed before, they're pretty clearly talking about militia service. But that gets cut in the final version. So which way does that cut, right? Does that demonstrate that we're departing from this reference to militia service, or that's what was really going on at the time and we cut that provision for other reasons? So there's a lot of different things that you can look at through these changes. The last thing that I do, so I go through the amendments in the same way, and then the last thing that I find interesting is looking at the US Constitution compared to the Confederate Constitution. And the Confederates, a lot of people don't even know that the Confederates even had a constitution. But the Confederates had a constitution, and what they basically did was redline. So here's the Confederates Constitution. They basically redlined the US Constitution. And I think you can, by looking at this in redline, the changes jump off the page. Their greatest grievances with the Union jump off the page. So first of all, obviously all these changes to the Confederate states, but where the Constitution goes through pains to avoid the word slavery or slaves, the Confederate Constitution is crystal clear about what we're talking about with slaves and slavery and adding protections for slaves and slavery. There's a single subject rule. Article 2 changes quite a bit in the Confederate Constitution. The president serves one term of 6 years, and then they're not eligible for re-election after that. Another thing that I find interesting they make a lot of changes here, but there's a discussion now about the what's referred to as the unitary executive theory, which I'm sure a lot of you are familiar with. But the unitary executive theory posits that within the US Constitution, and if it's something within Article 2, the president has unitary authority to do anything he wants basically within Article 2, including hiring and firing anyone within the executive branch. And the theory says that this is sort of inherent and implicit in Article 2 of the US Constitution. If you look at the Confederate Constitution, drafted 75 years after the US Constitution, Article 2, Section 2 says, the principal officer in each of the executive departments and all persons connected with diplomatic service may be removed from office at the pleasure of the president. Okay? All other civil officers of the executive departments may be removed at any time by the president or other appointing power when their services are unnecessary or for dishonesty, incapacity, inefficiency, misconduct, neglect of duty, et cetera, et cetera. So basically making explicit the unitary executive theory in the Confederate Constitution, which raises questions about whether it's implicit in the US Constitution if the Confederates felt the need to be explicit about it in their Constitution. There's all kinds of stuff you can sort of explore by looking at these documents in redline and looking at these documents side by side. So hopefully this has been somewhat interesting for you. I think we've got some time for questions as well for Ryan and I, but thank you for being here. And I do have some signed copies of this out on the back table. If any of you are particularly nerdy like we are, there are some copies back there that you can go home with a copy of these documents that we're talking about. But happy to take any questions. Sure.
I have a question. Thank you. The portion of this that is so new to me and to many of us is the correspondence preceding the Declaration of Independence. I was interested in the way one of the 1774 document was captioned as like a combination of colonies, a combination of interests. And I wonder whether that any parallel undertaking was done in the 20s when we were drafting the treaty to end all wars, League of Nations. They had the same problem, bring separate entities together. Did they borrow anything from our experience?
So directly around the 1920s, I mean, I will say a lot of these documents, there have been parallels made between these and being akin to international agreements. And they have a lot of the same flavor as an international agreement, right? It's sort of a voluntary coalition of otherwise sovereign states, not really giving up much of their sovereignty, but agreeing to a common cause and with similar problems with enforcement mechanisms. So there are I am aware of parallels there with treating a lot of these different, especially with the Articles of Association, like an international agreement. I don't know if Ryan, you have other thoughts on that?
No.
I know I spent most of my time at the founding era.
Yeah.
I haven't quite made my way to modernity yet. Yeah.
This 1647 agreement refers to basically universal male suffrage. But isn't it true that in most of the 19th century or first half of it, men had to have property even to vote? And when was that injected? That would seem very contrary to.
Yeah. Certainly it is. No, this was definitely for its time a radical document in the Levelers, and then a group that was even more radical called the Diggers were kind of amusingly named, but it was certainly radical at the time and not, didn't go into force, I don't think, in any laws. And I mean, there's a push for universal suffrage, like in some people like Jeremy Bentham later on, but that's, early 19th century and late 18th century. So no, it didn't get much traction in that movement. I mean, I guess the point is that sometimes a movement can produce a really extraordinary document and folks will keep it in mind for a while, and it will hang around. There's some, scholarship that says that the Levelers had some impact on John Locke and his conceptions of popular sovereignty. But no, some of these things get kind of shelved for a while. Yeah.
A related question is, in the British Parliament of that time, how representative was the House of Commons? I know that it became very unrepresentative after population shifts in the Industrial Revolution, but surely there must have been a lot of MPs that were ecclesiastical or had other, didn't really represent anyone. Was there not any effort to say, hey, this should be a fair delineation of numbers versus votes? And
that's what they were concerned. The people like the Levelers were concerned about that coming out of the English Civil War. But around the time, during Edward Cook's heyday in the 1620s, no, there wasn't that kind of equal representation. They, generally come from the gentry class in the House of Commons. Ecclesiastical figures generally are spiritual lords in House of Lords, so that's even more with the aristocrats, and that's hereditary peers. So that's quite, unequal. We still have some of that today. But yeah, the House of Commons was certainly, with the, kind of was large, property owners who were, who really had a lot of local power. even if they were not aristocrats, coming out of their boroughs and out of their counties. So yeah, it's a great point. And of course, it continues into the 19th century.
The only other thing I'll add is in the initial draft of the US Constitution, basically the convention had got together and compiled a bunch of what they thought should be the draft constitution. That's the Committee of Detail gets that draft and works from that. But the convention had agreed on certain things as a starting place. In that starting place, there's a property requirement for before you can vote. And that gets cut. James Madison says, absolutely not. It's like antithetical to everything we're trying to do. It convinces enough people to not agree with that. The other thing is, I always like to think of like, who's the most future-proof sort of the founders, or at least of the drafters. John Dickinson had a draft of the Articles of Confederation where there was universal suffrage for men and women and abolition. And so he's to me, Dickinson, Paine, Franklin, some of these people had more future-proof ideas than others. Yeah.
Briefly, given that these fundamental rights stretch back so far, whether it's habeas corpus or takings clause, why did the framers of the Constitution walk out of their convention with no Bill of Rights? They waited until Congress was in place to do it.
Yeah, they walked out without them because there was a sense, there are a couple things. One, states had constitutions, look to your states to protect those rights. The federal government's not gonna be that powerful anyway. We've given the federal government limited powers, and so we don't really have to worry about them oppressing rights that much. And it's generally a consensus, but a lot of the anti-federalists say, we don't trust that. Like, we think it's gonna grow and grow and grow. We don't trust that. We want a Bill of Rights. So they got assurances before, if we ratify this thing, we promise we're gonna have a Bill of Rights, right? But that's why they were able to leave initially, is because they didn't think that the federal government was gonna be strong enough to oppress rights anyway. And if your state oppresses your rights, you're covered by your state constitution that have a Bill of Rights.
The anti-federalists were also great future proofers, it sounds like.
I think that's true, yes. With a lot of caveats that the nature of the country has changed a lot, including after the World Wars. And the federal government has grown in a way that it wouldn't have been conceivable. But after the World Wars, it starts to become more and more conceivable. Yeah.
So that could be 1100s. Which fundamental rights people want that?
Yeah, it's a great question. I mean, the provisions in the document are really sort of restoring some sort of equity or fairness to the way that fines are handed down. The first clause in the Charter of Liberties of Henry becomes the second clause in Magna Carta, and it's on a death tax. And it says the death tax must be fair. They don't say exactly what it is, but it was not the way it was, enforced or imposed in the time of my brother, William Rufus. So, and then in Magna Carta, they specify it, exactly what that death tax should be, so there's this like process of clarification in succeeding documents. That's kind of interesting. But yeah, it's these kind of general statements, and they're referring to customary law. So they're probably, it's easy to say very general things because it's hard to point to exactly what is fair and, fair and accepted by the people.
On that point, I think that's one of the most useful takeaways from this type of project. And it's one reason I sort of wanted to compile all this stuff, is to make this argument, especially with the courts looking more and more to history and tradition, to be able to make this argument that this fundamental right is not just something that comes from Reconstruction or comes from the American founding, but this has a long history through English tradition that's unchanged. And then identifying the fundamental rights that are unchanged and where the founders departed from English tradition, because they departed from English tradition in various ways as well. So identifying those things, I think this is a useful exercise for that. I know we have a lot of these documents in the Rare Book Center. There's a 1789 Constitution, there's a Magna Carta, there's an original of Common Sense. There's all kinds of great stuff down there. So I know we'll be down there for a little bit to discuss this thing more.
Yeah, please come down if you can, if you have time. We'd love to have.